All right, good morning. It is February 21st. This is Senate Health and Welfare. And we are going to go through S 192 with Ledge Counsel, Katie McClin, who is here. So Katie, why don't we do this? Why don't we walk through the bill and then see if we can get to some good place?
Okay. Wait. Take us to some good place. I'll do my best. Good morning.
Thank you,
Katie McClin, Office of Legislative Counsel. Let me share my screen. So we're looking at draft 7.2. This was the same version that was posted yesterday. And this has the changes that you've been working on, really last week. You made some changes and some decisions, and this draft embodies all of those changes and decisions. So I will go through and point out where those changes were made. They're highlighted in yellow. So first, you have a date change in your purpose and intent section. It had been that the friendly facility would be open by July 1/24. It's now July 1/25, and you've removed language about where the facility would be located and how many beds it would have. So you'll notice that I'm not showing the strike through because I have a fear of it going to the Senate Secretary's office with that and being printed in the calendar that way. So I just removed it, so it's gone, and I'll try to remember where I've removed strikers. Next, we have the Human Services Community Safety Panel. There's some lead-in language. Well, there's some language in the that sort of defines who this facility is going to serve. So beginning on page 1, line 19, the panel shall be designated as the entity responsible for assessing the potential placement of individuals at a forensic facility pursuant to 134821. That means individuals who have been found not competent to stand trial. For individuals who present a significant risk of danger to self or others, if not held in a secure setting, and are charged with a crime for which there is no right to bail and are found non-competent to stand trial due to mental illness or intellectual disability. So we added that in to clarify who we're talking about. Don't have any other changes in that section. I know that's a conversation that you are hoping to circle back to about the panel. Section 3, we made the technical change of adding in the person's legal guardian on page 3, line 2.
What's that stuff after any? Looks like a semicolon, a comma, and a dash.
Oh, after any. So you're striking through the comma and adding a semicolon.
Ah.
I know it looks confusing, but that's what's
That's good,
happening
thank
there.
you.
Other changes in this section, this is where this section and subsection C describes what the panel is looking at and determining whether a person should be placed in the forensic facility. And you change dangerousness factors to risk of harm factors. Other changes to that section. Okay, page 6. This is a new section that you've added. If you remember last week, I brought in sort of a separate document that was a handout with proposed changes that has been integrated now. So what that looks like is adding this new section 4 and removing 3 sections of the bill, the previous 5, 6, and 7. And those sections pertain to application for involuntary treatment, hearing on the application for involuntary treatment, and orders on involuntary treatment. Instead, we have this one section. This is in Title 13, the criminal justice title, and we have now sort of a parallel construct with intellectual disability in that after there's been a finding of that somebody is not competent to stand trial, there's sort of more of an automatic process that the court starts looking at whether placement in custody with the commissioner is appropriate. So this language reads that if the court finds that a person is a person in need of treatment or further treatment, the court shall issue an order of commitment directed to the Commissioner of Mental Health and shall admit the person to the care and custody of the department for a period of 90 days. We heard testimony from the Department of Mental Health that indeterminate didn't really mean indeterminate because the court has narrowed that. So instead, you're just saying 90 days and you're consistent with what the language is in Title 18. So that is, for the most part, existing law. What you're adding to this section is subdivision 2. If the commissioner seeks to have a person receive treatment in a forensic facility pursuant to an order of non-hospitalization under subdivision 1, so the preceding subdivision, receive treatment in a forensic facility, the commissioner shall submit a petition to the court expressly stating that such treatment is being sought, including a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment for the person's condition can be provided safely only in a forensic facility, and the recommendation of the Human Services Community Safety Panel. Then in subdivision 3, this is the court order. If the commissioner determines that treatment in a forensic facility is appropriate, and the court finds that treatment at a forensic facility is the least restrictive setting adequate to meet the person's needs, the court shall order the person to receive treatment at a forensic facility for a period of 90 days. The court may at any time following the issuance of an order on its own motion or on a motion of an interested party review whether treatment at a forensic facility continues to be the least restrictive option. So you moved a lot of the language that we had in those 3 Title 18 sections, so that they're right here. And as you know, if somebody needs treatment after that 90 days, the processes get kicked over to Title 18, where an application for continued treatment is filed. And that's where we're moving to now. So first we have a definition section. We have a definition for what's meant by a forensic facility. And then we're clear that with regard to individuals in the custody of the Commissioner of Mental Health, we're talking about persons in need of treatment or continued treatment. Same thing for individuals, the top of page 8, individuals in the custody of the Commissioner of Dale, that it's not just persons in need of custody care and facilitation, but also continued custody care and facilitation can be in the forensic facility. In section 6 on page 8, we move to the application for continued treatment. This is what I was just referring to. This is the person that after the initial order still needs treatment. An application is filed by the commissioner. I don't think there are any changes in this section besides renumbering. Then we have our hearing on the application.
Is that the Commissioner Dale?
Right now, we're the Commissioner of Mental Health.
Okay.
The first half of the bill is Commissioner of Mental Health. Yep, thank you. Going to remind ourselves where we are.
Still in mental.
We're still in mental health, yep. So section 7 is the hearing on the application for continued treatment. Section 8 pertains to the application for involuntary medication. And if you recall, subdivision A6 is where we have the change. The person has been placed under an order of non-hospitalization in a forensic facility is one of the potential criteria under which the commissioner can file with the court to have involuntary medication. The previous version of the bill had language about if an expedited hearing was filed for a person in a forensic facility or who was a candidate for a forensic facility, and that language has been removed. So you're not seeing that anymore. So 6 is a change, but what you're not seeing is what has been struck.
Say that again, what was struck?
Yes. In subdivision A6, there had been language that if a person was a candidate for a forensic facility, they had an application pending and the court had agreed to expedite the hearing, that in that situation, the commissioner could file for involuntary medication. And so that language has been removed because we got rid of the language about the expedited hearing when those 3 sections on application for involuntary treatment were struck and the language was moved to Title 13.
Okay.
So the expedited hearing,
It's not gone, like existing law still
Right.
exists, but the language about an expedited hearing with regard to somebody who's a candidate for a forensic facility, that language is gone and the resulting option to base an application for involuntary medication in that circumstance is gone.
So expedited hearing language exists in Title 13.
It's in Title 18.
It's still in Title
And it
18.
still exists in the same form. It hasn't been changed,
Hasn't
you're
been
just not amending it right now.
All right, good.
Okay, so now that brings us to page 13, where we change hats. So we had been talking about individuals in the custody of the Commissioner of Mental Health. Now we're talking about individuals in the custody of the Commissioner of Dale.
Now we're in Dale, we're in intellectual disability group, page.
So section 9, thank you. Section 9. So we're starting off, just as we started off the sections on mental health, with amending Title 13. And this is the language, we found that somebody is not competent to stand trial, and now the court is looking at whether they should be in the custody of the Commissioner of Dale. So we have language. I guess I'm pausing just to note that the language in this section and in 18 VSA 8845 that we'll come to are very similar. It makes sense because they're sort of cross-referencing each other, but I just wanted to flag the similarities there. And I went back and looked to make sure that the language was tracking. So we have very similar language and not identical language in places. And 13 around the initial commitment, and 8845 and 18 around the same the initial commitment.
And just maybe what is in 8845 to 8847, but
Do you want the overview? 8845 has to do with the initial commitment and process for that. 8846 is continued treatment in the process around that. 8847 is discharging a person from commitment or the forensic facility or both.
and does that include the notice provisions for
Yes.
those things?
Yes,
Okay.
that's an 8847.
And it includes notification to, well, state's attorney, prosecutor, like,
Yes.
the victim and the defense attorney, or
So the notice goes from Dale to the prosecutor. The prosecutor delivers notice to the victim if the victim hasn't opted out. And then in certain circumstances, specific to a discharge from a forensic facility, this draft allows for the victim or the prosecutor to have a hearing on the proposed discharge, the administrative discharge from the forensic facility.
thank you.
This first paragraph. Paragraph A, the up to 1 year, this is for commitment. This is not for
Yes.
forensic facility,
Yes.
right? So this is the thing I want to make sure.
Commitment to the commissioner.
Commitment to the
custody of
care and
the
custody of the commissioner, and it could be in a forensic facility, it could be in a community-based facility, it could be somewhere, anywhere, well, not anywhere, but within the options, but it's not necessary. This 1 year is not necessarily forensic facility.
Correct.
There's later is.
Later, we talk about the forensic facility, but it's important to remember that the way this is drafted, the initial order is up to a year, and the forensic facility order, if it is ordered, can be no longer than the underlying order. So it could be up to a year.
Right, and that's what I wanna talk about a little bit more when we get there, yeah.
Okay, so subsection A, we're talking about commitment. If the court finds that a person is a person in need of custody, care, and rehabilitation, that's our criteria, our clinical criteria. The court shall issue a commitment to Dale for placement in a designated program in the least restrictive environment consistent with a person's need for custody, care, and rehabilitation. Up to 1 year. 4 up to 1 year, good, 4 isn't there, okay. Subsection B, the commitment procedures for an order initially issued pursuant to A. And for discharge, for an order of commitment or continued commitment occur in accordance with Title 18. So we're cross-referencing those new sections that we've created. And C, in accordance with 18, if the commissioner seeks to have a person committed pursuant to this section placed in a forensic facility, the commissioner shall provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, including a recommendation of the Human Services Community Safety Panel. And then we move to Title 18. We have a definition section. I don't know that you've made changes here. Okay. We're striking the same 4 sections that have been struck all along. And then we move into 8844 hasn't changed since you last seen it. And then we move into the 3 new sections that we've really been working in. So I'm on page 18, if that's helpful, section 8845, and this is the initial order for custody, care, and rehabilitation. And you shouldn't be surprised to see that the first thing it does is cross-reference back to Title 13. So if a person is found incompetent to stand trial, it's the criminal division that shall automatically schedule a hearing to determine whether a person is a person in need of custody, care, and rehabilitation and requiring commitment. So do they meet that clinical standard? If so, should they be committed to the custody of Dale? The commissioner's recommendation that a person be placed in a forensic facility, if applicable, shall be filed with the court in advance of the commitment hearing. And shall expressly state the reasons of the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, and is to include the recommendations of the panel. In subsection B, we have language of who attends the hearing. So the commissioner or designee shall attend the hearing and be available to testify. All persons to whom notice is given may attend the commitment hearing and testify, except that the court may exclude those persons not necessary for the conduct of the hearing. C, we have which rules of evidence apply. In subsection D at the top of page 20, we have language that if this is the order, if the court finds by clear and convincing evidence that a person is a person in need of custody, care, and rehabilitation, the court shall order that person to be committed to the commissioner and receive appropriate treatment and programming in a designated program that provides the least restrictive environment consistent with the person's need for custody, care, and rehabilitation for up to 1 year. That's commitment. That's the initial commitment order. Then we have language that notwithstanding what we just looked at, a person may still initiate a judicial review under this subchapter after 90 days following a current order of commitment. So even if the initial order is for a year, at the 90-day mark, the person can still initiate their review.
And in this case, person means the person who's been committed.
Yes.
Okay.
Yes.
So it's basically on them to
Yes.
initiate this judicial.
So the defender, yeah, they're not, legal counsel or support services.
Right, but,
Yeah, right.
It's not something automatic that the
yeah,
department is bringing up or that the court is bringing up.
is this? Okay, but that's still just about commitment, that's not about the forensic, so.
Yes. Yeah, but it's about their current order of commitment, so. Well, the current order of commitment, yeah, it's about the commitment.
And in some cases, the commitment and the forensic facility are sort of, in some cases, one and the same. Because you can't be in a forensic facility unless you've been committed.
Yes. Yeah, so that's sort of an interesting point, because if there were both an order of commitment and a forensic facility placement. And you wanted to give the person the ability not to challenge the commitment, to challenge the placement after 90 days. I think you'd want to say something like following anytime after 90 days.
Oh, we're not at placement.
Yeah,
So
a current order of commitment.
this would go in
I
that,
think you'd need a word change. I think they could bring it.
Yeah, so even if they were in a forensic facility, if they've been committed and sent to a forensic facility, they could still
They
do
could use
this.
this, yes.
And it would, and if they make it make an argument successfully that they shouldn't be committed, then of course they shouldn't be in the forensic facility, because the only reason to be there is if you're committed.
Yeah.
Yeah, okay.
So subsection E, now we're turning to the placement. So if the commissioner has recommended to the court that the person be placed in a forensic facility, the court, after determining first the need for commitment, shall determine whether placement at a forensic facility is both appropriate and the least restrictive setting adequate to meet the person's needs. If so determined, the court shall order the person be placed in a forensic facility for a term not to exceed the duration of the initial commitment order.
So I think this is where, so this is placement in a forensic facility, and this is up to a year. And I'm trying to figure out in my mind if there's a way we can have a middle ground, because I hear Stuart, and I know he's floating up there somewhere, about the 90 days maybe being short, but I also think a year is a really long time. And when we heard from this bill, legal aid yesterday, I found their argument compelling to say, look, this is all on the person. And yes, they have legal counsel, but they might not be able to see their legal counsel very regularly because they're in a forensic facility. So I would rather have something that's automatic after a certain amount of time that just has to happen. And maybe 90 days is too short, but maybe it's, I don't know, 6 months or
180 days.
180 days, so that we have some actual automatic check-in and it's not on the person who's in the forensic facility to initiate it.
So, and,
You agree?
yeah, well, the concern that I heard from Stuart, and we'll go where floaters in just a minute, is that it will require a demonstration of no behavioral, change, so the individuals have to have been aggressive or done something in that time frame. So, and then the onus is on the department to prove that they've either done something or not done something. So Stuart, this is a difficult place, I know, because we had looked at 90 days. It makes a lot of sense to give some automatic review if someone is making progress. We've heard from you that making progress with an intellectual disability in this situation is extremely difficult. So a short comment here, we're trying to look for a way to compromise on the 1 year and the 90 days. The suggestion's been made for 180 days, so.
So I think I might be able to make it easier for the committee. So again, we have to think about it in terms of commitment versus placement in the facility. The department's argument has been that commitment determination should be no shorter than 1 year. I'm hearing from Senator Hardy that there's an interest in looking at reviewing the placement at the facility in fewer than 365 days. And so Dale would support looking at the placement at the time after the initial commitment at 90 days. That is fine. I think it needs to be clear, though, what the purpose of that challenge is at 90 days. It's not a challenge to the commitment itself, whereby the department has to prove the person is still a danger after 90 days. But it should be limited, we believe, to the issue of, is the forensic facility still the least restrictive environment? And if that's what the court is looking at 90 days, that is not problematic to the department. So maybe that's a solution for you guys. And we do question whether there needs to be 90-day reviews of the forensic facility every year thereafter. DMH does not do that. After someone is ordered to continue treatment to DMH, there's not a 90-day review every year thereafter of the placement. But we do support, we could support a 90-day review of the forensic placement after the initial commitment by the criminal court.
Right, and we had actually talked about that earlier, so it's, I think we're seeing some support for that suggestion. Senator Williams.
I'm thinking that if the individual has an intellectual disability, he's not gonna realize that he's eligible, and there ought to be some trigger there so that legal aid or whoever represents that individual knows there's time for a review. Just looking out for the individual.
Absolutely. So anytime there's an annual review, the legal aid, the attorney representing the individual is currently notified. So they're not unaware that this is happening. If the statute provides for a 90-day review of the forensic facility, then the statute could certainly indicate that notice shall be provided to the individual's attorney.
Thank you.
Yeah, I think,
That makes sense.
yeah, and Stuart, or maybe this is a question for Carol. Does this mirror what happens in the mental health? I mean, they have the 90-day review for placement of forensic facility on the mental health side, or maybe that's a Katie question.
So it depends. If someone is coming out of criminal court, then the initial order would be a 90-day order, and then it would switch over to an up to 1 year family court order. And so then we would have an affirmative obligation every year to refile and prove to the court that the person met standard to remain in our custody. However, if someone was had been in the hospital and then transitioned to the forensic facility on a application for continued treatment, so they've gone through their initial 90-day and now they're on the 1 year cycle, then it would be a 1 year order. Does that make sense? The 90 days is for initially coming into our custody, however you come in, whether you come in to the hospital or on an ONH. After 90 days, it's reviewed, but after that, it's up to 1 year. However, the person always has the opportunity through their attorney to contest that.
Right, so
It's commitment.
yeah, that's commitment. So what about for a forensic facility? Their 90-day review for placement in the forensic facility?
No, so it's the same as River Valley, right? So we already have folks that go to secure residential facilities. So the order is up to 1 year. We have the affirmative obligation to always assure that they continue to meet that level. And at any point, anyone can argue that they don't meet that requirement of a restrictive level of care. But no, those are 1 year orders.
Okay,
Well, but the court shall order the person to receive treatment at a forensic facility for a period of 90 days. So that's.
When
the
they're
treatment
coming from criminal court, yeah, but if we're coming off an application for continued treatment in family court, that looks different because they've already done the 90-day.
okay.
That was the point I was trying to make.
Yeah.
There's a difference
They've already
between the
done, yeah.
court that we're dealing with here. One is criminal court and the other is family court.
Yes.
I think we should
Yeah.
take Stuart up on his offer.
Hey, Katie, how difficult is it to do that, make that? It's initial placement only of 90 days with a placement review.
Right, just make sure it's still the least restrictive.
Right, and the department's only concern is that the statute be very clear of what the department's burden is, or what the individual's burden is, if that's the individual's burden to show it's no longer the least restrictive. But it should not be for the purpose of the court having to or for the department to have to show the court after 90 days that the person is still in need of commitment, but rather only the issue of least restrictive.
Right, yes,
Okay.
I,
Thank
Great.
you.
Is this going to the criminal court, or at this point would we be in the family division? Cause we're still on an order that was issued by the criminal division, but everything else after that initial order goes to the family division, so I'm not clear which court would be taking a look, which division.
So at 8846 is judicial review in the family division,
Right.
but that's comes
So this is-
after this, and this is the initial. This is 88. Is it 8845? It's 4821. No, it's title 13, and it is criminal division where this is happening.
Well, but that is where the initial
Right,
commitment order and placement is happening.
and initial placement, so it would have to go through criminal court for a decision on placement. I'm looking at, I don't have the experience to answer
Yeah,
that.
I- Right, so it's the criminal division that's making the initial determination of commitment and or and perhaps placement at the facility. But if there's a question at the 90-day mark as to whether it's least restrictive, I don't see why it would be treated any differently than what we have in 8845
Yeah.
that talks about the individual has a right to a judicial review anytime after 90 days following the order of commitment. It could be in the family division. I think that's what 8845 is contemplating, that all subsequent.
It's family division in 8845.
Well, it doesn't say that, so
Does it?
if that is the intent, I'm thinking on page 20, subdivision T2, we should say. Person shall initiate a judicial review in the family division. Family division of Superior Court. And then to be consistent, you would do family division for this new check-in for 90-day placement review. Does that make sense?
Yeah, I think so. The challenge is that the criminal division has the familiarity with the order, with the case itself. But so it's basically creating a petition at 90 days for that review. If
Or we could simply say there's an automatic review through at the criminal court at 90 days. I don't know
a
what.
policy call, I guess.
The difference between the criminal and the family court is the family court is closed, right? I mean, in terms of this case, and the criminal court is open, more or less.
I guess I'm also thinking about, like, after the initial order, everything that we've written transfers over to the family division. So, you know, you've created this layer that somebody could initiate a judicial review after 90 days. And it seems like you would want to be consistent, that if an individual could initiate an order in the family division, or then the placement review would be in,
That makes sense to me as
it
well.
doesn't make sense to me if the placement review would be in the criminal division, but the person could petition in the
Family.
family division. Unless I'm curious if
Can we,
your thoughts.
so I'm with the criminal division being consistent with that initial ask, but can we phone Eric?
Yeah,
Would that help you or?
my guess is you might say it's a policy just,
Apology, this is,
Yeah.
very much.
but I'm happy to consult with him.
All right, but I'm leaning
It's a
toward,
policy decision, what are the differences in terms of, that's what I was
that's why
trying
I wanted to phone Eric, and Katie on that one. So the difference between the criminal division, the Superior Court, and the family division and Superior Court for this, but the initial placement order is with the criminal division, so it would seem that would be the place where the information would exist for decision-making about the 90-day review.
the placement in the forensic facility is through the
Yeah.
criminal division.
Yeah, so that's why I'm leaning toward leaving it in the criminal Superior Court. But as I said,
Is the commitment also in the criminal division?
Yes,
that
it is.
the family-
Initial
The initial commitment, but then it moves to family.
Yes.
and it all moves to
Okay.
family after that. So then, but we'd have to be very clear that the 90 days, it only with respect to placement, not to commitment.
Yeah. I think if everything else moves to the family court after the initial commitment and the initial placement, then it should go to family court.
And all the information goes to family court.
Yeah, because if the commitment, all the commitment stuff goes to family court anyway, then
It does. My concern here, and it's a legitimate difference there. The concern is that you've had a placement based on criminal behavior and other behavioral issues. The court's familiar with that, and it's a very short period. of
Yeah.
time. That's all. So, but
if that's,
after the 90 days, you've got a year, then.
then it's all in the family court anyway.
Yeah, it's all
So
there anyhow.
it doesn't matter to me that much.
I don't know.
If you
Yeah.
prefer the criminal division, Sure, let's do that.
Well, let's start with it and
Let's
then
do it.
see what happens.
For Tuesday. Let's be done.
Okay, let's do that.
Okay,
Katie, and if
so
you,
you want the 90-day placement review in the criminal division.
Yeah.
But you want the person to be able to petition after 90 days in the family division.
The 90-day automatic
Yes.
is in the criminal division.
keep it in the criminal,
But,
so the criminal court knows it's coming,
okay,
that,
and then,
and everything transfers to family.
so if a person after 90 days seeks a judicial review of their current order of commitment,
That still goes in the
That
family.
goes to
That's an
family.
order of commitment that they themselves can ask for a review of. Yes, that.
that
would go to
stays in the family. Okay, great.
Thank you.
We got it. Okay, that work?
Thanks,
Well,
Stuart.
we don't know.
Stuart said it would be easy, but not for you.
Katie's got it.
Very.
There you go. That's a big step, I think. All right.
Okay. We've made a decision on that. Now we'll move to page 21, 8846, and this is the petition for, and the order for continued custody. So, language is that if prior to the expiration of a previous commitment order that was issued under Title 13, or the subchapter, so it could be that the person has already gone through an order for continued treatment. The commissioner believes that the person is a person in need of continued custody care and rehabilitation. The commissioner shall initiate a judicial review within the family division. The commissioner shall, by filing a written petition, commence proceedings for the continued custody care and rehabilitation. The petition shall include the name and address of the person alleged to need continued custody care and rehabilitation and a statement of the current and relevant facts on which the person's alleged need for continued custody care and rehabilitation is predicated. Any commitment order or continued commitment order shall remain in force pending the court's decision on the petition. So that's, so there isn't a gap between filings. On the top of page 22, if the commissioner seeks placement for the person alleged to need continued custody care and rehabilitation at a forensic facility, the petition for continued custody care and rehabilitation shall expressly state the reasons for this determination, that clinically appropriate treatment and programming can be provided safely only in the forensic facility. It is to include a renewed recommendation from the panel. And then subsection B, upon receipt of the petition, the court shall set a date for the hearing within 10 days from the date of filing, which shall be held in accordance with this subchapter, so that those cross references mean who's allowed to participate and what are the rules of evidence.
8845, yeah, and then we go on to the order of commitment for up to a year.
Yes. Should I skip over that?
Good.
Okay,
Yeah.
page 23, there's a new sentence that nothing in this section shall prohibit the commissioner from seeking nor the court from ordering consecutive commitment orders when the criteria for commitment are otherwise met. That's to address the concern that was raised that you might read one that a order of continued commitment is for a year and then say, oh, we've already done our year, so we can't refile. So this is sort of saying, no, the commissioner can seek consecutive orders. And then we have small changes in subsection D. That brings us to 8847, which is discharge. Would you like me to go through this a little bit more slowly? Or are you, well, how about this? Subsection A talks about the 2 ways to discharge a person. Subsection B is the judicial discharge, both of commitment and facility. We have some language, some cross-references that cross-reference the language about the person's ability to do the 90-day review, both for commitment and continued commitment. And then, what page am I on? 25. this is language about we're still in the language about the judicial review. So when a person who is subject to judicial review pursuant to the subsection B is receiving treatment or programming at a forensic facility, either the prosecutor, or the victim or both may file a petition with the court as an interested person concerning whether the person's discharge or placement at a forensic facility is appropriate. So that is for the judicial review that the prosecutor or the victim could file.
I've had a lot of communications about that one, so it's good.
Okay. And then in subsection C, we're moving to the administrative discharge, lots of changes here. So if the commissioner determines that a person is no longer in need of custody care and habilitation, of continued custody care and habilitation, or of placement at the forensic facility, the commissioner shall issue an administrative discharge from commitment or placement at the facility or both. The administrative discharge from commitment or from placement at the facility may be conditional or absolute and have immediate or delayed effect. At least 10 days prior to the effective date of any administrative discharge by the commissioner from commitment or placement at a forensic facility, or 10 days prior to the expiration of a current commitment order for which the commissioner has decided not to seek continued commitment. The commissioner shall give notice of the pending discharge to the committing court and to the prosecutor. And then subdivision B.
Is there a
Yeah.
wait, hold it, state's attorney. And then are they required by statute to? give
Yeah,
notice?
we will get to that.
Yep, okay, good, so, sorry.
Can I ask a question? So
Yeah,
why is it that there's all this more complicated stuff for an administrative discharge versus a judicial discharge? What happens with a judicial discharge?
Right now you have language that, the prosecutor
May
or
file a
victim
petition.
may file a position with the court. So my assessment is that it is, well, actually, I don't know if that's true or not. It's more public so that there would be notice.
Yeah, I mean, it feels like we're creating all these complicating things in the administrative discharge. And can't we just make it simpler? I'm a little worried about all the. It feels like it could be held up for a very long time in the administrative discharge, but with the court's discharge, it would be much simpler.
well, I don't know. Cases can be,
Well, because if the commissioner decides to discharge, then
you think
then it
that
would go to the court if there's a,
from
and
commitment,
yes.
Yeah.
And then, so it's taking an administrative thing and making it a court thing.
both commitment and forensic facility being combined. Katie, what is your thinking on that?
Yeah, there's more process involved
Yeah.
with
Yeah, there is.
administrative discharge. As this is drafted, in the judicial discharge, the prosecutor or the victim does have an opportunity to have, have their voice
Yeah.
heard in front of the
So
court.
can't we just put it as simply in the administrative that that they can appeal?
They would need notice to know that
Yeah, that is
discharge is happening. I guess what I'm sort of contemplating is taking all of the embedded language out and having a separate standalone section that says anytime a person is discharged from a forensic facility, either judicially or administratively, or they are on an order that is not gonna be renewed. Within 10 days of the discharge, notice has to be given to the prosecutor. The prosecutor has to give it to the victim if not opted out. And then within that notice period, if an appeal to that decision is going to be requested, it has to be requested in that 10 days. The court would set a hearing for within 10 days and then an order within 5
What, within 5 days?
is the timeline.
Yeah.
So that would be a total
Yeah.
of 25 days
Yeah,
that it
that-
could be. So is that right, that after it would have to be done in 25 days?
Yeah, so, so you have to give 10 days notice of, yes, 10 days notice of the discharge. So in theory, that's part of the person's order, so, you know, because they haven't been discharged yet. So you give notice, let's say you, give,
The victim gets
So-
notified.
right, so within 10 days, the prosecutor and the court has to receive notice. Then let's say, the prosecutor doesn't give notice to the victim until day 9. Then they have 10 days from getting that notice to request a hearing. So now you're 10 days out. And then the
20.
hearing is within 10 days.
Well, the hearing is within 10,
I
like
think
5
5.
days.
The decision was
5,
five
oh, okay.
days. So yeah, 25 days it could extend.
I'm trying to think, you really can't do it any less and be fair to all the parties involved.
Is this the same as for mental health?
My understanding from the conversation with Karen, and I will let Karen answer that question, is that there was a lot more nuance on the notification pieces than to simply be parallel.
I
And so that is why this structure was created. But for the details on how the notice works for mental health, I would have Karen answer.
So before we do that, Stuart, you're still there. Do you want to comment on the administrative release from commitment and placement?
Certainly, thank you. First of all, I should say that administrative discharges are extremely rare. I think I can think of maybe 1 or 2 that have been issued. Generally, it's the judicial process that an individual goes through to determine that they're no longer in need of custody care and habilitation. But that said, I think the structure here was designed to balance all of the interests, to make sure the victims have an opportunity to weigh in. And I think there's language in here that we were just talking about making sure that there is a very small window for the notification and that the order be issued within a certain number of days. So we're not talking about these orders extending indefinitely to the detriment of the individual. There will be some finality within a reasonably short period of time if an administrative discharge is what's pursued. So I like the structure the way it is. So
I'm looking at that language. We haven't quite, yeah, I'm looking at page 26 and 27 where it has puts the brackets around the time frame. So
just want to make sure that the time frame is. I mean, if 25 days is not a lot of days, but so it
depends on who you are.
I mean, it depends on who you are and where you are too. 25 days could be a really long time in a forensic facility, probably is. So I just don't want it to just like drag on for too long. And I get,
Well,
you know, that timeline.
Katie, let's go through this language briefly, the yellow that we have there, because it deals with the time frame and page beginning 26.
Okay. Okay, so we're in C1. Administrative discharge. If the commissioner determines that a person is no longer in need of custody care and habilitation, continued custody, or placement at the facility, the commissioner shall issue an administrative discharge from commitment, placement, or both. The administrative discharge from commitment or placement at a forensic facility may be conditional or absolute. At least 10 days prior to the effective date of the discharge by the commissioner from commitment or placement, or 10 days prior to the expiration of a current order, which a follow-up order is not being sought. The commissioner is to give notice the pending discharge to the committing court and to the state's attorney or the AGs if they prosecuted the case. In subdivision B, and reviewing the placement of a person receiving treatment and programming at the forensic facility. The commissioner may determine that while placement at the facility is no longer appropriate or at least restrictive, the person is still a person in need of custody, in which case the commissioner shall discharge the person from placement at the facility while maintaining the commitment order or continued commitment order. And in subdivision 2, while a person subject to an administrative discharge is receiving treatment or programming at the forensic facility, the state's attorney or AG's office, if they prosecuted the case, shall provide notice of pending administrative discharge from placement at a forensic facility and from commitment, if applicable, to any victim of the offense for which the person has been charged who has not opted out of receiving notice. So just to highlight, they're getting notice of discharge from placement at a forensic facility and from commitment if applicable. So it's the forensic facility discharge that's triggering there. And then subdivision B, during the period in which the commissioner gives notice of the pending administrative discharge, so that's the 10 days before discharge, and the anticipated, so this shall not be less than 10 days, which we already know from the first subdivision from the subsection. The prosecutor or the victim or both may request a hearing in the family division on whether the person's pending administrative discharge from placement at the facility is appropriate, which shall be held within 10 days after the request.
So they have to give notice not less than 10 days, so they
Yeah.
can't do it on day 9. It is 10 days before.
Yes.
Yeah, that offers some clarity. Okay.
But
So then we're going to the hearing.
The order is not within 5 days.
yeah, I guess I'm looking at this again to try to figure out how long they have to request the notice. Sorry, request the hearing.
Name request a hearing and family. There isn't a time on that, is it?
During the period when the commissioner gives notice.
So. How about?
It would have to be within the period before the effective date of the discharge, right? So there'd be a date of a discharge of the individual, and the state's attorney, the attorney general, or the victim would have to file their position before the effective date of that discharge to stay everything.
So there has to be a certain number of days before that effective date.
It would have to be within the notice period, which is before the effective date of the discharge, which couldn't be less than 10 days.
So essentially you have to give 10 days notice that the person is being discharged. And then within that 10-day window is when you have to ask for the hearing. Yes, I agree. Okay. And then the hearing is to be held within.
Complex situation at the time. Mostly that, yeah. If you start looking at it, you think, okay, this works.
And so then you have your repealing your sunset in section 11, section 12, you have your report on the competency restoration program. And you ask that the estimate shall include whether and how to serve individuals with intellectual disability in a competency restoration program. And then you have rulemaking. I made a change here because there can only be one department that is in charge of rulemaking. And because Dale is the department on record of maintaining the TCR rules, I have them filing the rules in consultation with DMH instead of having both of them filing jointly. And then as I suggested I would do in subdivision 2, this includes allowing emergency and voluntary procedures to be used at the secure residential recovery facility, not just involuntary medication that was
Okay,
requested by the department. And then effective dates, you have the your so. Yeah.
Um, the only, I don't love the bill, but mostly because it's just a really hard topic to
Difficult.
deal with, but the only thing I still don't love, is the panel. And I know you want the panel, so can you explain to me why you think the panel is appropriate and necessary?
well, the only reason that I think the panel should stay here right now is that it's consistent with what the department's doing. And so it will reinforce the work of the department in contacting and collaborating. We could change the language to be consult with. I guess, and I don't mind talking about how to improve that language. My thinking is we have concerns about the panel, whether it's the right thing to do, whether it should be interested parties, or how to expand that a little bit. My thinking is let's leave it as it is, and this has a ways to go. When it gets to the House, they may have some suggestions, and we can certainly, when we take the bill to the House for introduction, we can suggest that they review the panel, because they'll spend a lot of time on it. So that's all.
I don't have a problem with panel, it's just.
Yeah.
Putting
I mean, I think does add some value in terms of recommendations, coming from different departments for the individual decision maker.
Yeah, I mean, I think it's just overly formalized, and prescriptive, and I think having the commissioner just shall seek the advice and consultation of these people and disability rights. That's the other thing is having that commissioner shall seek the advice of, or the opinion of disability rights as the sort of ombuds person kind of thing. But I know, I hear that the committee's tired of working on this bill, and I'm willing to say, let's just tell the House to dig into this more so that we.
We will, I think, and we've got all the secretary commissioners, disability rights certainly can have a role to play here, as would others, so I think interested parties becomes a very good way of saying it, but.
Right, I mean, it doesn't make sense to have legal aid because they're the defense, so I understand.
No, I agree with you.
But having the whole concept of having some kind of ombuds person for people who are in these facilities, I think is important, and having them consulted before somebody is placed in it, I think is important. And that's what I think is missing.
Okay, my question is,
I'm happy to,
no,
let
before you
us
go
do
there,
that.
my question is, if we list disability rights, the council that is by law part of the state government, if we list them on the panel, what consequences are there of that? And I'm probably looking to Stuart.
That's a good question, Senator. I'm not sure what the consequences, if any, would be from a legal perspective of adding additional parties to this, but I still come back to the position that Karen and I were articulating last time we met, which is that this is supposed to be, it's designed to be an internal decision, which can later be challenged in the courts by Vermont Legal Aid, by disability rights, standing alongside Vermont Legal Aid. This is really designed to be the internal recommendation of the department to the court. So while I understand that there's a desire to add, whether it's the DD Council or disability rights at this phase, we can expect that there will be opposition from either or both of those entities at the recommendation stage. So to what end? We will hear from those organizations that forensic facility placement should never occur, should not occur in this particular circumstance. And then what? The commissioner will still make a recommendation to do it. And then it will go to court. And the court will have the opportunity to weigh whether it's appropriate or not. And that's when disability rights, the DD Council, those other parties could come in and argue that it's not appropriate. So there is an opportunity for that voice to be heard. It just, to my mind, doesn't make sense to include it at this stage.
Okay, all right, so
I'm fine with leaving it the way it
let's
is for
just
now.
leave it as it is. This is not
Ask the
gonna
House
be
to
a
dig
simple
into it.
conversation when it moves to the House. I think we've made huge strides in the bill. Thanks to Katie,
Nice job.
really big steps.
Katie.
And Stuart and Karen, thank you
Yeah.
both. So let's do this. Are there other sections of the bill that we need to go through again?
You've just gone through it all, it's just that one change that you identified in this walkthrough.
Okay, so we'll make that one change and then we'll come back and look at it. Like,
Can we just vote it out and be done with it tomorrow?
it's up to Katie. Did you have a
I just
question?
had a process question.
Yes.
So I understand at one point in January, we were talking about the estimated cost of the facility. When the bill gets introduced to the floor, does it have any kind of cost information?
There's no
Why-
fiscal note on this.
Why is that?
There's no, we're not initiating the building of the facility. We're saying when it's available.
There is a cost associated.
Yes, and that's been, I think, institutions has discussed that. And so the capital budget would include whatever other costs are there, whether it's bonded or whether there's anything from the general fund that would be an appropriation. So
So how does that work? Does this go
This-
cost to them or does it just go?
no, this doesn't have an appropriation.
Okay, that's what they don't understand.
So
It does.
remember, if it's our intent that the facility be authorized and operational beginning July 2025. That's an intent. But it would also lend itself with what's actually proposed in the capital budget or appropriations. But this bill doesn't say build it.
Can I follow
We'll
up?
ask Nolan that question.
I support the bill.
Yeah, no, I understand. I know
I
why.
just don't support the process because it's, very visibly. it's
Oh,
gonna
well, if-
cost and we should
Well,
articulate.
how about yearly costs? And I also support the bill, but it would be good for all of us for our
Right.
notification to know what it's gonna cost each year.
Well, there was testimony in January.
We have
It
that.
had roughly 11 million per year
Yeah.
cost. Okay, we get that, but
Got
I'm just wondering why it's not,
No fiscal note? So
whatever the process.
This is anticipatory of how someone would be placed, should there be that $11 million or other dollars available for the retrofit of Berlin into secure forensic facility. So this is what happens to people if and when that,
If people's part, the other part is the facility.
yeah, no, I agree, but, and the other part has been discussed already, and I think I have to look, I don't know what's in the capital bill. That one. And I know this has been discussed now for several years, so this is a good question, and we'll reach out to folks, I think. Jennifer, Fitch is the person to reach out to and try and get some understanding of where it is in terms of funding.
Well, okay, so
That's it. Yeah, yeah, no, I agree.
I'm ready to vote it.
I mean, these changes that we have in this bill could happen whether or not there's a facility, and then they're just there if there is a facility.
It's like prevention.
You know what I mean?
Process of what to do with the people, I get that,
Yeah,
very clear.
Yeah.
But the facility itself is, no, that's
So
the.
the alternative, but
right.
let's go back. The alternative for the folks we're talking about here is jail.
Yeah, I get that.
There's no,
I'm
that's
with-
not the least restrictive place. And that's, no, and I think we all agree, that's not a great place. Unless we change the way jails work.
I just don't understand the legislative process and how we develop a program but not articulate the cost to build and sustain. That's all I'm saying.
Okay,
I support everything you're doing.
Weird.
wait, I'm not doing this one. You're not gonna blame me for this.
This is helpful.
Like Kate,
Please.
Might
Kate.
not be helpful. The testimony you heard from EMH was that there wasn't currently an appropriation in the governor's budget. And so the reason why the July 125 effective date was selected was that gives another budget cycle to see if it is funded next year. And if it is not, or if the date needs to be amended, then the July 125 date gives you next session to make that adjustment to the effective date of the facility if it needs to happen.
Thank you for that reminder.
Yeah.
So maybe it's the governor who needs to be inquired.
Right.
Okay. So, Katie, is there a way that we can look at the final draft tomorrow morning? You're not here tomorrow morning.
I don't know where I hit that.
You can't be here, I understand.
Oh.
No, yes, you can, at 10:45.
Yes.
So can we have the new draft and then, at that point, entertain a motion? So rather than,
Today. 2 months.
Yeah, that sounds great.
Thank you so much.
I think we're gonna take a 2-minute break, we'll go offline.